Welcome to part 6 of Discrimination Education. We're talking specifically about employment discrimination. That's discrimination in the workplace. In the previous video, I promised that I would go over what someone like me, who's a professional in dealing with employment discrimination situations through the administrative process of the EEOC, what someone like me can actually help you with. Now, like Denzel Washington said, it's not what you know, it's what you can prove. And in terms of making a legal argument through the administrative process, retaliation is one of the most effective arguments that a complainant or a charging party can actually bring to the EEOC. And that's because of the case law, the way that Supreme Court justices have interpreted the law regarding retaliation. Retaliation, the idea behind it is to try and stop employers from retaliating against individuals who bring a charge or bring up concerns about discriminatory practices in the workplace. So we're going to talk about some of the elements of retaliation. Okay, number one is that you engaged in statutorily protected activity. And the standard for determining whether or not you did that is that you had a reasonable belief that something wrong was going on and you said something about it. That's the first part, basically. The second element is that you suffered an adverse employment action, okay? And the standard for that is that whatever they did to you to retaliate would dissuade a reasonable person from making the same type of complaint that you made because they saw what the employer did to you. They say, you know what, I don't want that to happen to me. I'm gonna keep my mouth shut. So that's the standard for that. The third element that we look at is a causal link. And that causal link, in most cases, courts are looking at, and the EEOC will look at what the courts have done. They're going to look at, okay, 3 months or less between the time that you engaged in statutorily protected activity and the time that you suffered the adverse employment action. And if there's a 3 month or less gap there, then you have a pretty strong prima facie case of retaliation. Prima facie is Latin for on its face or at first sight. And in the next video, in part 7, I'm going to talk about a little bit more about what happens after you establish your prima facie case of retaliation. If you like this video, I want you to please like it, share it, subscribe, and I look forward to seeing you again. My contact information can be found in the description. See you in part 7.